This podcast is sponsored by Tusk, an open source non-ICO crypto project powered by community. Check them out on the web at tusk.network. That's TUSC.network. The Rob McNealy program is the nexus of cryptocurrency, blockchain technology, and entrepreneurship. Now, welcome to the program. Today, I am so excited because I get to talk to someone that I really like to talk to. In the crypto space, I really like to talk to really smart people, especially securities litigators and attorneys that really understand both the legal ramifications of crypto, but understand the technical and community aspects of crypto. So today, I'd like to welcome to the show, Doug Pepe. How are you, Doug?
I'm great. Thank you very much for having me. I'm excited to talk to you, Rob.
Well, I'm really excited to talk to you too. I know it's been really hard to get a good time frame window with you because you're obviously so busy. So before we jump in right about what you're doing with your project, can you just give our listeners a little bit of a background on who you are for your quote unquote day job?
Sure. Well, my day job is as a commercial litigator. I do complex commercial litigation, which runs the gamut from, hedge fund disputes to, bank-to-bank disputes to mass torts and that sort of thing. Usually on the defense side, represent a lot of law firms that get sued for legal malpractice for things including, opinion letters and securities fraud cases. That's basically what I do. Sort of high dollar complex commercial litigation.
So unlike a lot of attorneys in the crypto space, you're also an entrepreneur, and that kind of sets you apart. And actually, that's what we're talking about today. We're actually not here to talk about crypto law specifically. So tell us a little bit about your project, Mango Farm. Sure.
So Mango Farm was a project that started, I've been involved in crypto for, several years, 4 years. And, I had never really done anything in crypto in terms of, starting a company or, coding anything. I set up a mining farm, sort of a medium-sized mining farm, small by today's standards, with a friend of mine, a partner of mine, and I've just been very interested in sort of the legal aspects of crypto and the technological aspects. So one day, and I've told this story before, but one day my friend, said, why don't we put together some mining rigs with our kids and, get them started on a gaming PC and they can start to mine with it. And we got a bunch of parts. We put all the, put the computers together and our kids started mining. We built a big mining farm, from our perspective, for our standards, a big mining farm. But, it wasn't enough for me. And I've been, sort of keen on crypto for a number of years and hadn't started any sort of a company or project. So when I got involved in, learning a bit about Ravencoin, tokenized assets, what the Ravencoin platform could do, I decided to start my own little project. So late at night after my wife and kids were asleep, I started coding the first version of what is Mango Farm. And what we do is, and from that day to this, it's been, pretty much every day of the week at night and on weekends working on this project. It's a small project. It's sort of, very much in the startup phase. But what we do is provide tools for people to tokenize real-world assets on the blockchain without the need to have a computer science degree. So we've got a little catchphrase. It's blockchain assets made easy. That's our goal at Mango Farm, is to make blockchain assets easy for people who can't do it otherwise.
So specifically, you've developed a set of wallet tools that specifically work on the Ravencoin platform?
Sure. I mean, you can take out your phone using our platform, and you can tokenize an asset in less than a minute with full metadata. You can include attachments, you can include icons, legal documents, contracts, tokenize the asset, even encrypt. I designed an encryption system for Ravencoin. I open sourced it. You can encrypt the underlying metadata using the system right on your phone. It's pretty cool.
So
we've been working really hard on it. I mean, it's, nobody knows about it other than people in the Ravencoin community, but we have been working really, really hard on it. And it's still very much in the beta phase, but, it's coming together.
So are you a coder as well, or just an attorney?
I'm a little of both. I used to code when I was a kid, right? So I would not consider myself to be an expert coder. I mean, there are real experts in this field. I'm not one of them. I know enough to be dangerous, but what I'm good at and sort of what I've transitioned into the role of at Mango Farm, I coded the first version completely myself. But I transitioned a little bit into a role of sort of, I come up with the concepts, and I'm the member of our team now who remains sort of the most well-versed in the blockchain stuff, the script language stuff, you know, sort of the old school coding stuff, and I do all of that. So right now, for example, we did encryption, now we're working on atomic swaps, and sort of the methodology for doing the swaps and all of that came from me, and sort of the first cut version of what the swap should look like at a script level, that came from me. And now sort of the JavaScript and the back-end coding and all of that's being done by a colleague that I brought on because he's a much better coder than I am, to sort of implement. And we're an awesome team. The two of us we work well together because we iterate against each other pretty much all night long. It's great.
So your atomic swap functionality, is that between Raven assets, like a Raven to Raven asset, or from
Sure.
Raven to other crypto assets?
Right now, what we're working on is Ravencoin to Raven asset. The same concept though can be applied generally. It can be asset to asset, or it could be another crypto. If we did, you know, cross-chain swaps with a hash time lock contract, we're not at that phase yet. We built out now the sort of all the functionality for Ravencoin to Raven asset swap, and now we're basically putting together the front end, the look and feel, the UX, and all of that. So we're going to put that out soon.
So what inspired you of all things to do a wallet? It seems like if I was going to jump into a project,
Yeah.
which I have, a wallet is not the sexy thing that you think of at first. Why would you start with a wallet?
Yeah, exactly. Well, Mango Farm really isn't a wallet. A wallet is one of the tools that are needed to build a blockchain asset, right? It started with the builder. So we have a thing called an asset builder. That's a simple web form. It's got a set of metadata fields. You can fill it in. You can attach documents. You can put an icon to it. And that builder was sort of the origin of the whole project, which was just to, you know, make a simple web form that people can use to build assets. From that, it expanded to, well, if we're going to do a builder, you have to sign, right? So if you're going to sign to create the asset, to sign the transaction, you need a wallet to do that. There were two ways to go. One way was to have sort of the web form, the simple web form, sort of integrate itself with a QT or a daemon that the user actually has on their computer. That was one way to go. I wanted to go the other way, which was build a wallet. So then I had to build all the wallet features, had to do all the signing on the client side, had to get into all the crypto, learned it all. And assets were actually pretty interesting because at the time, this was now around Christmas time of 2018 was when we went to the wallet. There was nothing out there that signed Ravencoin asset transactions. There weren't any the dev kit wasn't even out for Ravencoin. So basically we built it from scratch, straight from the crypto, which was fun because I learned a lot. But that's why we did a wallet, and then we're building other tools. The wallet is basically the repository for it's a web wallet, so it's not a repository for large amounts of Ravencoin. It's basically a vehicle to allow you to put Ravencoin into the system so that you can make assets with it. Asset building is really the focus of the platform.
So you're basically creating a whole, usability layer on top of the Ravencoin platform to make it a lot easier and accessible for everyday users.
Exactly, because when I was monkeying around, let's say the summer of 2018, when testnet came out with the asset layer, before it launched in November, the 5th of November 2018. But before that, on Ravencoin, testnet was available, and I was monkeying around. This is what gave me the idea. I was monkeying around making assets. I was using IPFS to build out the metadata. Tron Black, who's the lead dev of Ravencoin, published the spec for standardized metadata. And I was making the JSON myself by hand, and spinning up an IPFS node daemon, and making the IPFS file and attaching. It was a very manual process that you had to go through. And my first idea for this was, well, why not just automate this and make it all simple? So I started with Tron Spec. We don't use Tron Spec anymore. We have our own because we just wanted to add some features like multiple attachments. But I started out by using Tron Spec and building this sort of application layer to allow people to tokenize assets very simply. I mean, the goal is to make it so simple that anybody can do it, and my kids do it all the time. So that shows me that we're headed in the right direction.
Yeah, probably still more complicated than I can handle, I'm guessing.
Well, we're trying, I don't think so, Rob, but we're trying to make it, easier and easier as time goes on. And that's the goal. Like for encryption, for example, I mean, to encrypt data for an average person who's not versed in, setting up the PGP keys and all that, that's hard for most people. And so we did it with sort of point and click. Here you go, create your, we call it an encryption receiving address. It's a special address that has a PGP key associated with it. And you can encrypt and decrypt asset metadata literally by just pointing and clicking on a website. Our goal is to do that with swaps, which we're working on now. And we have a few other things that we have in the pipeline. And when we're done with all that, then we're gonna go back to making the whole platform sort of look and feel a little bit more professional. It's still a little wonky looking. So we're leaving that for the end.
So how are you funding this project? Do you have outside investors, VCs, angel money?
No, self-funded. Yeah.
Wow.
But I do a lot of the work. I'd say 50% or 60% of the work is me. In terms of the concepts and the blockchain related stuff and the going back and forth. We do have a developer that we now have hired. I have a partner who's my good friend. I would say it's more my sort of labor of love than his. But the two of us, fund it together. And we have, so Mango Farm is a public platform that's there. Basically, it's free. There's only one thing we charge for on the platform, which is the encryption. And we're not doing it to make money. I'm doing it to test, the concept of charging for these sorts of things. But it's 25 Raven to create this encryption receiving address once. You make $0 off of it. But Mango Farm is, if I have my druthers, Mango Farm is going to always be free. It's not there to make me money. It's there as a platform for me to learn and continue developing these tools. And then we have sort of a separate side project going on, which is, if we're going to make money with Mango Farm, this is the way we're going to make it, which is that we're white labeling it for specific asset classes. So we have two, one of which we own, the other which we own a percentage of the company. Someone came to us. I can't disclose what it is now as I'm sitting here. It's coming out soon though, and we've been working on it a lot, very hard, which is a specific asset class that uses the Mango Farm tools plus the swap feature that we've been working on for a pretty cool outside the box asset class that really has a need for the tools that we can provide. So we signed up with that back in the summer, and we've been working pretty hard on the side. There's nothing out there about it other than the fact that I'm saying that we're doing it. And in a couple of weeks, maybe 2 months time at the outside, that's going to be coming out. It's pretty cool.
Could your set of tools be used or applied to other blockchains?
So the answer is yes, with modification, right? I don't really have the same degree of knowledge with other asset-based blockchains that I do with Ravencoin, just because I've been working so much with Ravencoin. Theoretically, you could use similar tools to those we built to put a second layer on top of Bitcoin, as an opcode, although you wouldn't have the sort of UTXO benefits that Ravencoin has. And I don't want to get too technical. I don't know how technical your audience is, but I mean, one of the key benefits of Ravencoin from my perspective is that every asset has its own individual UTXO, which you can't get with Bitcoin unless you use a second layer like Liquid. I don't know all that much about Digibyte. There are platforms out there though that I think you could use similar tools, and I think people are building similar things on other platforms. But I like Ravencoin. I like the fact that it's, I like the ethos of the project. That's what attracted me most to it, and that's what got me started building. And so I think I'll continue to build. We do want to add other decentralized projects to the wallet side of our platform. So we are going to add Bitcoin. Probably going to add Litecoin. I'd really love to add Grin, but I don't know enough right now to know if we can do it, in a simple and clean way. And I really like Flow too. So we're looking at other things to add. They're relatively easy to add. I mean, all the tools are the same because Ravencoin is based off of the original Bitcoin source code. So the answer is yes. Some of our tools are going to be used. We're going to add other projects. In terms of the asset building, no, I think we're pretty much going to stick with Ravencoin. Maybe when I learn a little bit more about Flow, maybe we'll sort of consider using OIP in some way. But I'm still, this is an iterative process. It's an everyday process. Each new thing is a new thing that I'm learning. So, doing swaps came from conception to, implementation in a couple of months of me reading and learning and doing. Same thing with encryption, so sort of biting off chunks, getting them done, moving on to the next thing. So eventually I'd say, maybe 3 or 4 months, we are definitely going to add Bitcoin, probably Litecoin, and then I'll see about other coins to the wallet.
Oh, well, we'll have to talk about that. But I'm always thinking about my own personal self-interest on any of these projects. But I think you dovetailed into or segued into a really good point, is that it's amazing. And once you start getting into the technology, you see the other opportunities that present themselves once you have a better understanding of the space and the ecosystem.
It's amazing. The more I learn, the more I learn, the deeper down the rabbit hole I go. And look, I have a more than full-time day job. I also have 4 kids. I wouldn't be doing this if this wasn't a very serious passion that I have. And I just love to learn. So the more I learn, the more I realize I don't know, and the more I want to learn. And that's been the course of this mango farm experience for the past 1.5 years, basically. Yeah.
Do you ever see yourself segueing into the world of cryptocurrencies and the mango farm project full time? Or is that a goal, or is it just something you see you'll keep doing on the side?
I'm sitting in my law firm right now. So, look, I love it. That's all I can say. For me to transition fully from my legal practice to blockchain full time would take a lot in terms of, just being able to, my family's accustomed to a certain way of living. My kids are in private school. So if I were left to my own druthers, and I'm just going to say this honestly, if I didn't have a wife and 4 children, I would have done this 1.5 years ago. But I do, so I can't. But I'm very interested.
I hear that. And, people say that about, us because we have a community project too. And,
right.
and, same deal. Like for us to go full time in it would be very expensive.
Yep.
Because I have 4 kids as well.
There's a big opportunity cost. And you can take risks for yourself, but you can't take them for your family. So that's where I am. Yes. The answer, I want to give you a short answer to your question. Yes, I do want to do it full time.
Well, that's good. And I appreciate the honesty. And I wasn't just trying to put you on the spot. I was more trying to gauge your level of passion, for it, kind of thing. Some people are like, oh, I just want to dabble and play around. Or some people are like, no, I'm really, I see this as the future and I want to be a part of that.
Do you remember Spinal Tap when they had it up to 10 and you could go 1 louder? I'm at 1 louder.
Yeah, exactly. And, I can completely relate because you were a drummer, I think, right?
I was, yeah. I mean, I still am, but not as good as I used to be when I was a kid. Yeah, I was, I played drums for most of my life before I went to law school. And it was a real passion. I used to play drums for 12 hours a day. Literally 12 hours a day. I play until the wee hours of the morning. Pretty much every day. It was my thing.
Yeah. Did I ever tell you that I was in a metal band and a grunge band when I was in college? Lead singer, actually. I'm a first tenor.
You're kidding me.
Nope. No, the band's name was Bludgeon, actually.
I love it.
So I can relate. And,
well, someday you and I will have to, get a kit and get some musicians to jam around a little bit.
That would be fun. I would love someday for me to be able to go back into that passion. I actually used to sing in formal choirs as well, classic choirs.
Excellent.
So actually the last choir I was in wasn't that long ago. So, but yeah,
well, it's great that you're keeping up with it. I mean, that's the hard thing, is keeping up with it. I played in a band. I'm not in the band right now. I could go back, but I played in a band for about 2 years. And stopped. My wife got very ill. She had cancer. So I had to stop basically for that. But before that, I was playing, at least once a week, and we played out, say, once every 3 months at a local club or a bar. And it's just great to get out there and do it, So I think it's awesome that you're still singing.
You are not a typical attorney.
I don't know what a typical attorney is.
Not as cool as you. I'm thinking polymath. That word is coming to mind right now.
Well,
But it's good
appreciate
to
the
know.
compliment.
No, but I'm serious, because it's like it's good to see, someone that is really, really intelligent but gets it. And a lot of times you'll find people that will, have a certain expertise in one area, but they'll be lacking in every other area, like common sense.
Yeah.
Certain developers come to mind in this regard, but you seem to get it, and you're well balanced, and I think that's important, and I think it'll definitely take your project to really high levels of success. So as far as being a securities attorney, how do you, that must skew how you look at crypto and crypto projects. Does it scare you more that what you know about securities laws and stuff being in this space, or does it make you more confident that you are avoiding, minefields?
No, it interests me. That's one of the things that interests me. I mean, my background in terms of my professional background, right? I had a background in economics, mathematical macroeconomics. That's what I studied in school. Then I went to law school. I got out. I practiced as a litigator. I'm not a corporate lawyer, so I don't give sort of before the event advice as a general matter in my day job. I get to see things after the fact. In securities cases, typically there's securities class actions where, the alleged misrepresentation occurred. Rarely do you have a question of whether something actually is a security. I had one big case where that was the centerpiece of the case. It's a case involving this alleged Ponzi scheme by Alan Stanford down in Texas and Louisiana. I represented the law firm, a law firm that was involved in that. But I don't get a chance to really analyze these things in my day job unless I have to, unless it's for a particular case. And then you really drill down and you become an expert in that very narrow issue. What I love about crypto is it's sort of got pieces of all of the things that most interested me in my life, other than music. The sort of computer science, coding, scientific aspect of it, the social construct that surrounds sort of blockchain governance and Nakamoto consensus versus the sort of the approach that Ethereum's taking, through to the economics, the tokenomics, the economics, the game theory aspects, which I was really interested in when I was a kid, when I was in college, to the legal aspects. So I really sort of like the whole big picture, and that's what drew me. That's what drew me to crypto. It wasn't, sort of you can buy Bitcoin today and you can sell it for 20% more a week from now. That really didn't interest me at all. It still doesn't interest me. So that's what drew me to crypto. I don't really practice in the crypto space. I'm working as sort of an advisor for an exchange. But other than that, I don't really practice in this space. I do teach it though. I teach blockchain law and technology at GW Law down in DC. What I love most is that it's a space where the rules haven't yet been set. The rules are still being made literally day by day, case by case, as we go. And that interests me the most because, each new day you have a new filing by the SEC, you have a new speech, you have a new statement, you have the framework came out, it changes the analysis, it changes how you view things. And I think, it's going to take about 10 or 15 years for the courts to sort out some of the issues that have been paramount post sort of, the egregious ICOs that happened in 2017, to sort out, where, separate the wheat from the chaff, and sort of draw that line of what a security is in the context of crypto. It's a very sort of interesting dynamic and analysis, and I'm looking forward to getting some, case law, which is where law is really made. Law is made through official formal regulations and cases, interpreting whether those regulations comport with a statute. It's not made through speeches, and it's not made through sort of side consultations. And over time, we're going to start to see case after case after case in various jurisdictions in the U.S. start to come up with, attempts to define, where the line is between a security and a non-security. As those cases sort of ripen, you'll start to get conflicts among the circuit courts, which are the higher level courts, the first level of appellate courts in federal cases. And ultimately, maybe, 15 years from now, we'll have the Howey of crypto out of the Supreme Court. And, we could get a completely different test out of that case, or they could stick with the Howey test. It's going to be really interesting just to see how this progresses.
You know, the one thing as a project that's worked really hard to, actually not do things that are illegal and get in trouble
Right.
and all that stuff, just from the regulatory risk side of it, is it's complicated because, and in my day job, I'm an expert witness, so I'm fairly good at looking at rules and laws and understanding what their intent was. The problem comes in, especially with these guidances from a project standpoint that I'm seeing, is that a lot of times they'll give you 3 or 4 examples of how their guidance could be applied. The problem is what we want to do isn't one of those examples.
Yeah.
So what do you do in that case? And that's the problem. Like I've had a situation recently where I think I look at something and I read it this way, and I've talked to, attorneys about it, and then the attorneys disagree with each other, and you're like, what do you do as a project at that point? Because I mean, if you make that mistake, even if you don't have, a malicious intent or something, you can get in a lot of trouble.
Definitely.
And I think that regulatory risk, now there's a lot of people, like 2 years ago, they didn't care, right? They just like, ooh, throw it out there. We'll raise, $30 million in 10 seconds. And, it's worth whatever the risk is. But guys like us that are like, 1, I don't want to go to jail. 2, I don't have, millions of dollars to fight this anyway in the bank. What is a project to do?
Well, see, that's look, the SEC has provided, we'll talk about SEC, we can break this sort of into chunks, but I mean, the SEC has, I think, done a great job of at least trying over the past 2 years to give more and more and more guidance. I mean, there was no guidance before, right? And, there have been a couple of speeches, there was the framework, there was the Dow report, they're making I think a concerted effort to reach out and say, these are the sorts of things we're looking at the SEC. But it's difficult, right? These are rules that are typically applied to sort of major capital raises by, significant institutions that are sort of being applied at a granular level to small startups in an uncertain context, right? That's what makes it difficult. If you have a startup and you want to raise capital, you want to set up a corp and you want to raise money from people, the rules have been set for many, many years. These are the types of lawyers you can go to. This is the type of advice you need. This is how much it costs. It's sort of not cookie cutter, but there's a process, right? And that process has been worked out over many, many years. With crypto, it's sort of that whole process was sort of applied instantaneously to an area that still remains uncertain. I mean, there's a lot of debate between people over whether, just look at the Graham case, right? There's a debate in that case as to whether the underlying token itself is the security or is the investment contract something separate, right? It's not so clear. And what happens if you I tweeted about this the other day, actually. I mean, what happens if you have boxes of graham crackers, right? And they're branded boxes, and you sell those boxes to a set of initial purchasers. Let's say 1,000 of them, or 2,000. You sell the boxes to them, and you say, I'm going to use the proceeds of this initial box sale to market the heck out of these branded graham crackers, right? There's 2 questions involved in that. First question is that an investment contract? Probably. Second question is, are the graham crackers themselves the securities? Is there a difference between the investment contract, the sort of agreement or understanding between the promoter saying, give me your money in exchange for these graham crackers, I'm going to use that money to build out this ecosystem for making these graham crackers increase in value, versus the graham crackers themselves? Are those securities? That's going to be dealt with, I think, in the Southern District in the Graham case.
Well, that sounds like, and that's where, the argument of like, is the utility of whatever the thing itself is when they're combined, does that make something different from crypto than a typical investment contract, right?
Even my class struggles with this. I mean, anything can be a security. You can make an investment contract out of anything, right? That's different, though, than whether the underlying thing itself, the thing, is a security. Or is the investment contract something different? I have my own views. I'm not going to state them, because it's just a debatable issue. And that's what I love about this space, is that there's lots of debatable issues like that. But I want to hit your question directly. It is hard, right, for small startups and thankfully the SEC has started to give some guidance, and FinCEN has put out excellent guidance. I mean, their guidance is actually pretty darn clear. I mean, you can read the FinCEN guidance and you can sort of know where things stand. Not always, but for the vast bulk of general applications, which I thought was good. But you can't operate in the space without a lawyer. I mean, you just have to have legal advice. Maybe that will change over time. Maybe the rules will get more solidified. Maybe courts will start to issue decisions that clarify things, setting that line in a sort of judicially recognized way. The SEC can back away from a staff statement in litigation. There's nothing that binds the SEC to a staff statement. In a particular jurisdiction, if the Second Circuit Court of Appeals, which is the court that we have here over New York and other states, issues a decision, if you're inside the Second Circuit, that decision's the law. So over time, you're going to start to see the law develop. And I think it will make it easier. But for now, to have any project that involves anything close to money transmission, any project that involves anything that's close to touching on whether it's a security, you just need good counsel.
Absolutely. You've also been pretty vocal on your Twitter account about accredited investor laws.
Yeah.
Tell me about your kind of position or opinions about that.
So, look, the accredited investor laws are interesting, right? Because the legal framework surrounding the accredited investor rules is it a public offering or is it a private offering? That's what the statutory distinction is between public and private. And it's sort of morphed. There was a Supreme Court case, 40 years ago that said, it was a case involving Ralston Purina and and sort of the employees of Ralston Purina getting stock. And the court said, if it's an offering to a group of people who can fend for themselves, it can be considered a private offering, right? And what does fend for themselves mean? It really means, are there informational asymmetries, or is this class of people capable of, analyzing and understanding the risk? That's sort of how it was subsequently interpreted by the SEC. So the SEC passed, the accredited investor rules in the early 80s, basically, trying to put a fine line. It's a safe harbor. It's putting a box around. If you only issue the securities to these accredited investors, you're okay. That's a safe harbor. It doesn't really. It's not even designed to address that public-private distinction. It's saying if you satisfy these rules, you're going to fall within a private offering exception. Now, I just think the rule is targeting the wrong thing. And I think it, back in the early 80s, it probably didn't have that major of an impact, but entire industries have now been sort of created surrounding the notion that there are two classes of financial citizens in this country. One class is, those who have wealth or sufficient income under the rule. They get to participate in the party. And another class of citizen that are, I don't want to say stuck, but they are limited to investments in the public markets for the most part. I don't think that's the right way to go. I think if the question is, and again, this is not really what the statute says, but if the question is, do we only want people who can understand risk to have the ability to invest in certain classes of securities, then, I like Tron Black had an idea. I thought it was brilliant. Have a test. I don't know if it was his originally, but, have a test, something similar to sort of a scaled down version of what broker dealers need to take. I forget the broker dealer test, but there's two tests, and one test is the test that you take in order to be able to take the Series 7. Something like that, almost like a driver's license type thing, to see if people can understand risk. But I don't think, limiting an entire class, all of private equity, all of hedge funds, many real estate investments, oil and gas, all sorts of lucrative, and in some instances, very safe investments out there that, and I don't know what the percentage is, but it's something like 90%, maybe more, of the American population is completely barred from participating. I just don't think that's fair.
And what's the general litmus test to be an accredited investor right now? A lot of people here might not know what that is.
I think it's a million. It's funny. I haven't done this in a long time. A million in assets, 250 in income.
I think it isn't it. I think it's 300 if you're married, right?
Yeah.
I think it's 300 a year in income if you're married, and then $1 million in net assets, excluding your home or primary residence.
Excluding your primary residence. I only had this come up in one case. It was actually that case that I told you about, which was it was a Reg D offering. The question was, were these certificates of deposit securities? And one of the issues in the case was, did the company properly authenticate that all of the people who were receiving these certificates of deposit were accredited investors? Look, there's an example, right? These were it turned out fraudulent investments, but take a good security that sort of fit within the mold of what that company was doing. They were defrauding people, or allegedly defrauding people, but take that mold and make it, turn it into a safe investment with proper disclosure. Why should regular folks be precluded from investing in that? Why should regular folks be precluded from investing in a hedge fund?
Well, I mean, you look at it, these same folks that don't meet the accredited investor regs can go and play the lottery ticket in every state that has a lotto, which has really, really much higher risk. And don't even get me started about scratch offs and casinos, right?
I saw one article. I agree with you. I saw one article. I found it fascinating. It was on Twitter. It was an article from, I think it was the Boston Globe, but it was about the Boston securities regulator. Because, each state has its own blue sky laws. The Boston securities regulators barring people from investing in the Apple IPO because it was too risky.
Wow.
It was great. And that I saw that right around the time of the new proposed rules for the accredited investor, expanding the accredited investor rules to allow employees of hedge funds to invest, but not everybody else. Look, there's a rational way to approach this, and if the issue is, do people understand risk, then that can be tested. But I don't see wealth or income as having anything to do with. You can have an uber rich person who knows nothing about finance, and you can have a small business owner who doesn't meet the income threshold, is just under the the wealth threshold, and still understands the risk fully. You can have PhDs who are starting out as finance professors at the Wharton School of Business who don't meet the accredited investor test, but are some of the most sophisticated financial economists in the world. It doesn't make any sense.
Well,
I things that don't make sense.
I agree with you on that. And, I go back and look at, angel, I've been around the angel investing world a lot. I know a lot. I've looked at a lot of small business pitches, like hundreds of them over my life. And I can tell you that, at least as a small business and an entrepreneur, I've been an entrepreneur now for 20 years. And I can tell you that you learn a lot about risk mitigation and seeing opportunities being an entrepreneur that you would never have being like an employee of some other company, right? Because that's just part of, if you're going to be successful as an entrepreneur and you've been in a lot of different industries as an entrepreneur, you just learn these things. And I do think that they have an advantage when it comes to early stage investing, for sure. What I don't really quite understand and get is where the government drew these lines, because on the threshold of economic value, because you're right, I don't think there's a one-to-one relationship between how much money you've amassed and your knowledge of risk assessment.
There's not. So this for me is a matter of just general interest. It's not something that I do, but I did go back. I looked at the sort of regulatory history just out of pure interest. I looked at the regulatory history to sort of trace through the rules and trace through sort of the commentary from the SEC to the rules, to the regs, and it sort of morphed over time, and it morphed from that Purina case into this test. There was a period where the SEC had, you had the ability to, you could still invest in Reg D exempt offerings if you if you consulted with a financial advisor, which makes a lot of sense to me. And that like this rule, the problems that I have with the rule, I think would be largely eliminated if you know, your average Joe, in consultation with an investment advisor or a you know, a broker dealer, stockbroker, could invest, you know, using the knowledge and expertise of the person that's advising them on their investment. The difficulty I have is just borrowing a whole class of people based upon a criteria that doesn't target the issue that we're attempting to target. And frankly, none of it targets the question whether it's public or private.
Yeah, and I think and then it comes back to, you know, the more libertarian part of me says, why is this the business of the state to protect people from their own bad investments?
Well, look, you can invest $1,000 in a big screen TV, but you can't invest $1,000 in, you know, in some lucrative unicorn that really does have the potential to increase your wealth. It's very paternalistic from my perspective, and I understand the rationale behind it, and I understand the desire to protect people. But, you know, look, fraud is still covered, right? Fraud in connection with the purchase or sale of a privately issued security is just as covered by the law as fraud in connection with the purchase or sale of a public security. So it's not really about fraud; it's about informational asymmetries. And, you know, I think people are well suited. I believe in free markets. I believe in the ability of, you know, even average people, and I don't even know what that phrase means, but, you know, people who don't have master's degrees or college degrees in finance, to understand sort of innately the risks of what they're doing. And I rankle at, you know, sort of protectionist or paternalistic sort of approaches, like, you know, you have to be rich enough in order to be able to do this. There really aren't very many things in this world where we have a litmus test on whether you can or can't participate or buy it based upon, you know, how much money you inherited from your mom and dad.
It's not really fair, I don't think. And I think, you know, hopefully it'll change. But speaking of changes, what do you see, you know, coming down the road, litigation-wise, rulemaking-wise, that, you know, you're kind of got your ear, you know, to the politics side of it, or at least the legal side of it.
Yeah.
Do you see any major changes coming when it comes to crypto law over the next year, 2 years?
Sure. Yeah. I mean, I think we're going to start to see more cases. We're going to start to see a little bit more refinement around the, you know, sort of the security non-security line. I think, you know, we're going to start to see implementations of you know, financial action task force sort of principles, and we're going to start to see maybe a change here in the U.S. You know, at a granular level, but on some things, you know, the applicability of the travel rule and that sort of thing for money transmission purposes. I think states are going to start, I think, refining their money transmitter rules a little bit more over time. You know, right now a lot of states don't even have them, or several states don't have them. Some states sort of, you know, don't have clear rules that relate to crypto. I think we'll start to see more and more of that. I would like to see a bit of a change in New York's BIT license. I think the whole industry would, and I think that I sort of sense that that's coming. You know, we'll see. And I think you're going to start to see more sort of libertarian-leaning states like Wyoming come up with interesting new sort of legal vehicles for you know, that are sort of blockchain friendly, right? The one thing I know that Wyoming is thinking about, at least, is, you know, having sort of a construct for tokenizing assets. It's actually it's a really fascinating issue. I'm an advisor or an observer to this Uniform Law Commission committee. I'm not directly, you know, drafting anything, but I'm sort of an observer I'm a member of the American Law Institute, and the ALI gets observers on this ULC committee. ULC is responsible for the Uniform Commercial Code. And one of the hot button things that's come up in the ULC discussions is, you know, some choice of law issues. And let me explain what that means. So if I create a blockchain asset token, okay, and let's say that token is 1-to-1, no fractionalization, but that token represents the ownership interest in something, a widget, a piece of art, whatever you want it to be, some asset in the real world. could be a complex derivative, or it could be a, you know, something that's sitting on the ground like a rock. So, and I sell that, I create that token and I sell the token to you and you buy the token, right? Now we can have a contract between the two of us. And that contract can set out things like, you know, where one of the two of us can sue if something, you know, something goes wrong, what the law will be. That's a contractual right. And you need, in order to have a contract, you need two people that are interfacing with each other, and you need an offer, and you need an acceptance, and you need consideration, and then you have a binding contract. And that contract sets out the terms. But third parties, you know, secured creditors, third parties that may have some interaction with that asset, if you sell it to a third party without entering into a contract with them, you know, there are all sorts of legal issues that are implicated once you get beyond the me to you exchange and our agreement. Okay, I don't want to get too much into the weeds on the legal issues, but it's really fascinating. You know, that sort of issue doesn't exist with certain asset classes. So Delaware, for example, is the centerpiece of corporate law. And when you create a corporation in Delaware, that corporation is a creature of Delaware law. It's sort of created by Delaware law. It didn't exist before that. So then if you have a share in that corporation, the rights and obligations of the management of the company, the corporation, and the security holders of the corporation, those are all governed by Delaware law, no matter where you are in the world. It's called the Internal Affairs Doctrine. And the reason is because that corporation itself didn't exist but for Delaware law. The same concept can be applied, same thing with LLCs. So no matter who you are in the world, your rights and obligations vis-a-vis the corporation, if you're a shareholder, are governed by Delaware law, just from, you know, without any contract. I have a similar concept. I testified about this last year in Wyoming, and I think they're thinking about it. I know they're thinking about it, or at least considering it, is to have, you know, asset tokenization be the same type of concept. Just like you can set up an LLC, you can set up this direct ownership of a real world asset by tokenizing that asset on the blockchain. And this is sort of the idea is to have a legal construct similar to the creation of an LLC that sort of surrounds, envelops that creation of that token and the relationship of that token to the real world asset. Once you do that, then it solves all sorts of things, right? You can have, you know, in the statute, or you can have in the organizational document, the equivalent of the organizational document, that, you know, all disputes will be resolved in the Wyoming Court of Chancery. That the applicable law with respect to disputes arising out of the ownership of that token or the rights and obligations of the token holder to the asset are determined by Wyoming law. And then you can start to set up a body of precedent around this. So for me as a lawyer, that's really interesting. I hope things like that start to come out. So, you know, that's a long-winded way of saying, yes, I think there's going to be sort of refinement in the regulatory space, and also an advancement, I would call it, in sort of the usability, the laws that govern the usability of these things, these blockchain assets generally. So, yeah.
Yeah, I guess it'll be interesting to see how government looks at, say, a token. Is a token a share, or, you know, I look at, like, they have fractionalization ownership of, like, aircraft, for instance. Right. And so that's not a security, but where you're buying it as an investment, generally. You're buying it as just like, okay, there's 4 owners. You want to use it. There's 4 owners of this aircraft. Now, how that generally works with aircraft, I have experience. I understand how this works in the aircraft industry, the aviation industry. There'll be a company set up which actually holds legal title
Correct.
to that aircraft. And then, like, an LLC might be set up in Delaware or wherever. And then there's 4 owners. And then when there's a change in ownership, then it's just like if you're bringing on a manager to an LLC or getting rid of one. And I guess the difference would be, instead of having that paper change of, you know, legally direct ownership, now the question is, and this is where I think the technology is different, is physical possession of that token, as much as you can physically hold a digital token. But right. If you hold that token, now do you own legal title to the asset? And that's, I think, the thing that's hard to get even my own head around.
Yes.
Is it more just like a deed, for instance? So, if I have and the question is, provenance is part of this too, I would think, because
Absolutely.
just because you necessarily have physical possession doesn't mean you have right to have physical possession of that token.
Absolutely. I mean, you're raising a lot of really interesting issues. So the corporate model, right, or the LLC model, the sort of the, putting the asset inside a structure or a Delaware statutory trust, all of these things are vehicles, and the vehicle holds legal title to the asset. And then the shareholders or the LLC members or, the beneficiaries have beneficial title. They don't actually have legal title. They have indirect title to the underlying asset. So if you set up an LLC and you stick in that LLC one Picasso, and then you sell interest in that Picasso through the LLC, right? So you have 100 members of the LLC. Each one has a 1% share. That's not direct ownership. What I'm talking about is a little bit different. Doesn't exist, but
right. That's what I'm saying. It's new. It's a new thing. It's a new thing.
And they're going to be. But the answer to your question is it is uncertain, right? So if I create a blockchain asset and I say this asset is Picasso token, and Picasso token represents all right, title, and interest in and to the underlying asset. Picasso sauce pot in the kitchen, I think, is one of his paintings, right? Or Rembrandt, Aristotle contemplating a bust of Homer, which is one of my favorites, right? So if you have that construct, right, and then I sell, this is what I was talking about with choice of law, and I sell that to you, right? Well, how do you know that the state where you are is going to recognize that ownership interest? What if you move to another state? Is that state going to recognize the ownership interest? Is the state go ahead.
But how do you even know that blockchain had the right to sell ownership in that physical object?
You don't. You don't. Now you can do it with a contract, right? You and I can contract with each other that says, here's a notepad, right? And no, this is even better. This is a puck, right? If you and I agree that the holder of this puck owns the asset by contract, and we say, all right, title and interest is imbued in this puck, the odds are the court's not going to enforce the puck. The court's going to enforce our contract,
right?
Because we can contract basically for anything that's legal. Sort of very, very different than when you're dealing with third parties. When you take that puck then and you sell it to a third party, that third party may not be bound by whatever rights and obligations. And this is not just pure ownership. I mean, ownership is a bundle of rights, right? So some bundle of rights is going to it could be the possessory interest in the Picasso. It could be a non-possessory interest in the Picasso. It could with tag-along and drag-along rights. It gets, interesting, right? So if I want to create a bundle of rights, separate out a bundle of rights from the sort of pure possessory interest of a real-world asset, and I want to sell them to third parties, but I want to do it in such a way that all the rights and obligations between the various parties are not limited to the direct contractual relationship between me, the initial seller, and the initial purchaser. It gets interesting. That's why I sort of came up with this idea. I hope it gets some legs. It needs a lot of sort of thinking through and refinement. And believe me, I don't do property law as part of my day job. So, real estate lawyer might be actually better to sort of actually structure all of this. But look, I think vehicles like this need to be thought through because, before there was a corporation, there wasn't a corporation. And now our entire financial system basically is corporations issuing shares. Corporations were disfavored. They were frowned upon. New Jersey first and then Delaware after New Jersey sort of broke new ground when they switched the whole world from, sort of the big trusts that used to exist, most of which were in New Jersey, to the corporations that now rule our financial system. I think a similar thing can happen, but it doesn't, it relates to all assets. All asset ownership could be reposited on the blockchain eventually. And I think it, it's got a lot of potential benefits. Alienation of property and the free sort of flow of property is sort of has had a significant sort of historical impact on society. I mean, think about what the feudal system was. The feudal system was, peasants living on land that was owned by a lord that, working on the land, but they didn't own it, and they were unable to alienate their interest in the land. And think about from that day to this, how our property alienation system has grown, right? Same thing with any property. Any property can and should be, I think, tokenized on the blockchain and potentially fractionalized. But it's going to take a long time before these systems are in place because they're novel issues.
It's going to be complicated. Doug, we're running out of time. Where can I find out more about you, and where can listeners find out more about you?
Sure. So, I'm personally on Twitter. It's at Mango Farm Assets. You can find out more about Mango Farm at mangofarmassets.com. That's our wallet and our builder tools and our viewer on Ravencoin. I'm out there. I do podcasts like this. This is my first video one, but I do podcasts from time to time. And in terms of legally, most of the folks who are watching this probably wouldn't be interested in retaining my legal services because I'm a commercial litigator. But you can Google me, and it's Doug Pepe, and I'm really happy that you gave me the opportunity to speak with you because I always enjoy talking to you, and now we're doing it on video. So.
This is a trip, and I always learn more when I talk to you. Doug, thank you so much. Make
Awesome.
sure you check us out on the web at robmcnealy.com. Thank you for listening to the Rob McNealy program. Make sure you check us out on the web at robmcnealy.com and subscribe to our podcast at YouTube, iTunes, and on the Google Play Store.